It's Entertainment Law Update, episode 191 for May of 2026. Here we go. Hello again, everybody, and welcome to Entertainment Law Update. From Los Angeles, California, I am Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
And we are so grateful to you. Thank you for being here with us. This is the podcast by entertainment lawyers about entertainment law, where each month we round up notable cases and news and information to keep you informed and we hope a little bit entertained. And we would love to invite you to send us your feedback. You can do that, your suggestions, input, all those things. So visit entertainmentlawupdate.com. You can use the voice widget, the little red tab on the side of the screen, to send us an audio message, or just send us email, entertainmentlawupdate@gmail.com. So how are things with you, Tamara? What's new?
Well, they're great. As I'm looking at you, I'm like, oh, I kind of coordinate with your backdrop there.
Purples are good, yeah. For those who are listening on audio, I have a purple background.
Yeah, well, and I have on kind of a purple blouse today. Yeah. So you guys, this is a good plug for us to say. You can also watch us on YouTube.
That is correct. Well, I am crazy busy today. As I was just telling you, my oldest son, Nate, is graduating from high school this evening. So it's a very exciting and busy day for us here. It's funny, I was just thinking about remembering when we recorded our first episode, Nate was crawling around on the floor at my feet underneath the desk for our first couple of episodes. And here we are, almost 18 years later, and he's doing great. So it's exciting.
Yeah, that's super exciting. And he's going to be a duck?
No, he's going official? To go to I'm a duck, and so I had.
You're a duck, okay.
I had high hopes that he was going to go to my alma mater, and he was pretty excited about it. But he got a much better deal and admission at Sonoma State University, so the Seawolves, and so he's decided to go there, and where he's going to be studying creative writing. More power to him. And
where is that located? Is it a California school?
It's in the wine country in California. It's a state school here.
Okay, in Sonoma. Okay, got it.
Right near Sonoma. So, he's looking forward to it. It's very exciting around here right now. And anyway, we're thrilled that he's done so well. Congratulations, Nate, if you ever hear this.
I don't know about your son, but mine doesn't listen to the show. Yeah, well, only again if he's occasionally helping me.
Right. Well, listen, enough chit chat. Let's
get to work.
Jump right in. We've got a bunch of great stories here. The first one is just sort of a fun, interesting kind of a thing, where the satire site The Onion is going to be taking over the Infowars site that was belonged to Alex Jones. And as part of the bankruptcy settlement, the acquisition is underway. But at its core, it's not simply an acquisition. It's really a multi-layered media and legal inflection point. They've reached this agreement to assume operational control of this platform. It's part of that fallout from the defamation judgments tied to the Sandy Hook parents litigation for calling them liars and things. Those judgments totaled about $1.3 billion, where Jones falsely claimed that school shooting in 2012, gosh, that's a long time ago now, was a hoax. And so intellectual property and asset control play, not just a traditional acquisition. The Onion is targeting the brand ecosystem around trademarks, domains, production infrastructure, audience goodwill, all of that. And it's a twist because it's sort of an intentional flip it on its backside, kind of an inversion where you're repurposing this high-profile misinformation platform into a satire-driven property. So it's an interesting idea that The Onion would be now doing satire under the brand Infowars. So we'll see. There was a prior attempt to acquire it through bankruptcy auction. That was rejected by the judge over concerns about the process. The current structure is leveraging a Texas receivership model where a court-appointed receiver manages and monetizes the assets in order to satisfy the creditors. And now the Onion will operate it through a licensing framework while the litigation continues. So it's a proposed deal. It's not finalized yet, but they'll be paying $81,000 or so per month to license the intellectual property and preserving and potentially enhancing that asset value while they work out the final details of ownership. So lots of interesting stuff around trademarks and rights of publicity and First Amendment doctrine, claims of trademark dilution and false endorsement. All of these kinds of things can come into play. Ultimately, what comes into tension is the parody protection and consumer confusion components of things. So we will see what happens with that. Do you have any further thoughts about this?
Well, part of what I was reading on this is, how is the goodwill acquired? Which I hate to use the term goodwill in connection with this brand or this person. Yeah. Obviously it's a brand, whether, no matter how we feel about it, it does have a value as a brand and as a trademark, but you can only assign a trademark if you assign the goodwill. You have to assign the goodwill of the business. And then some commentators are questioning, and I guess Alex Jones and his defense team are questioning, if I don't come with it, has the goodwill been assigned? And then suddenly now, and kind of this flip on your head is, if you're making a parody of me, how is my goodwill being assigned? So I think that's an interesting something to keep in mind on that.
Well, I think one of the components is, what's the valuation of the goodwill separate from the rest of the intellectual property component? And is it reasonable to value them separately, or do you have to roll that all into the value of the trademarks that you're transferring? I don't know.
Well, exactly. you have to roll it into the value.
Yeah.
I mean, the value is the goodwill.
Well, so if it's $1 worth of goodwill and $1 million worth of commodity value or something, yeah. I mean, and I'm sure there's obviously content, I guess, which would not be a trademark value. It would be a copyright value. Yeah. I mean, and the Infowars brand
doesn't have goodwill.
Yeah. But the Infowars brand, I think, is a powerful, strong brand, and it's meaningful even to those of us that didn't care for the message behind it in its previous iteration. So I think it's going to be some work for the Onion to flip that. But I think that's a distinct value, a distinct brand from the Alex Jones brand. So even if he's not there, I think Infowars does carry some lingering goodwill or badwill or whatever you want to call it. It's definitely a consumer recognition form of goodwill. We all recognize it.
Right. And so here's what I just don't remember. Did he cover things other than Sandy Hook?
Oh, yeah.
Or was it just Sandy Hook? I can't remember.
No, I think Infowars has been a very right-leaning information or misinformation distributor. He was doing a daily show, so there must have been more.
Okay.
I never listened.
So, oh, well, and clearly I've just blocked it out. Anyway, that further supports there's value, I think, apart from him, is to say they covered other things. But, I think we do need to kind of just, big picture is, what is this precedent setting related to bankruptcy law, IP strategy, First Amendment? I don't know. We've had other issues when we've got bankruptcy related to trademarks and copyrights. We actually we have law in Texas related to consignment of rights when it comes to bankruptcy and sound recordings and copyrights. But then we've got this media asset with, quote, reputational baggage.
Yeah.
How does that work? Which kind of goes to my conversation, I think, about what is the goodwill.
Yeah. Well, there's also this notion here about is this, by essentially taking away the platform, the Infowars platform, is it sort of deplatforming Alex Jones? And I think it's important to remember that while he won't be able to connect the dots between him and Infowars anymore, his personal brand is still there. He will, he can always use his own name and start new broadcasting and whatever else under his own name. So his followers will find him. I think
that's right.
Yeah.
Yeah.
And who knows?
He's just not going to be doing it under Infowars. And then I also, it's, I guess part of buying an asset out of bankruptcy is you do have to increase that value of it, at least while it's still in the bankruptcy process. So it's not as if they could just license and shut down or purchase and shut down. Obviously, the Onion sees a value in changing the focus of this asset.
Well, at least until the bankruptcy proceedings, the receivership is done. They do have, the trustee or the receiver has an obligation of maximizing the value.
Yes.
But once it's sold and whatever, I mean, I'd be surprised at these prices whether the Onion was just going to let it shut down and kind of keep it off the market somehow. I think they have plans for it, but time will tell. We'll see. We'll see. So, this is an interesting case that we've had come up this month, is the Richardson versus Town Square Media, involving reproduction of some videos by a secondary, allegedly ostensibly a news site. So Delray Richardson is a videographer, the copyright owner in this case in question, and the defendant is the operator of XXL hip hop news website. The company is called Town Square Media. Richardson had created two videos. This is going back quite a ways, I guess. One was a video showing Michael Jordan intervening in some kind of a confrontation. So this was sort of paparazzi video, I guess you'd call it. And another was an interview video featuring rapper Melly Mel criticizing Eminem. And XXL published both of these videos alongside articles. They embedded the videos and used screenshots from them to illustrate the articles as well as promotional graphics. And Richardson alleged that was infringement of his copyrights and filed his suit. So seems pretty straightforward at the outset. He alleged that Town Square had infringed the copyrights by republishing and embedding the videos, that they had infringed by copying screenshots from the videos, and commercially exploited his works without permission. Town Square said, well, wait a minute, this is fair use, and it's de minimis use with the screenshots. And fair use the idea was that the Jordan video was reporting on a newsworthy event, and it was reporting and commentary. And then they also argued that because the Melly Mel video had been uploaded to YouTube, it was then subject to YouTube's terms of service, which allowed for embedding. And that's what they did. So this is in the Southern District of New York, which dismissed the case on the pleadings in favor of Town Square. Defensive judgment. The district court held that the Jordan video use was protected by fair use because the article added news commentary and context. Pretty quick to that judgment, I'd say. The screenshots, it said, were de minimis because they represented only isolated frames from larger videos. And the embedding was authorized under YouTube's license terms. So up it goes on appeal. And Richardson argues Town Square merely republished the entire video. This is the Jordan video for commercial purposes, and that the article was not meaningfully transformative. Town Square argued that it was protected news reporting and commentary about a viral public incident. On the question of the screenshots, Richardson argued that the screenshots were recognizable portions of his copyrighted works intentionally used to attract readers. And Town Square said they were too minimal de minimis, too minimal to support infringement liability. And then on the Melly Mel video, they argued that the YouTube terms Richardson said they didn't authorize commercial use with the embedding. And Town Square argued that, yes, it expressly does permit embedding, and it doesn't specify the kind of use or purpose of the use. So the Second Circuit takes a look and issues a mixed ruling. They vacated the dismissal on the Jordan video and on the screenshot claims, and they affirmed the dismissal on the Melly Mel video, the YouTube licensed stuff. So the first ruling was that the fair use could not be resolved on the pleadings. This is a jury question or a finder of fact question. And there were factual disputes remaining, whether that was truly transformative and whether it served as a substitute for the original work. And
and the court, well, as I say, out of the 4 factors, the court said, district court, you kind of didn't really cover 1, 3, and 4.
Right.
You know, it
purpose
just
and
wasn't.
character.
Did you
Okay,
really
there's
talk?
one. Right.
1, purpose and character. Did you really? And again, transformative is now purpose and character. The amount and substantiality of what was taken, and then the effect on the market, because there may have been no reason to go out and ever watch this other video from the plaintiff's video if I'm done watching it as part of what the defendant has put up. So I did love this quote, the Andy Warhol quote, though, Foundation, a use is transformative if it does something more than repackage or republish the original. And the court also said, quote, gesturing toward a transformation message versus actually communicating that message.
Right.
You could drive a Mack truck through that, though. What is gesturing toward versus...
Yeah, that's sort of interesting, because then how do you tell a jury that particular decision standard? But ultimately, I think what the court here was saying was, look, whether it's transformative is a fact question that the trier that has to be tried in a trial, or you can't decide it on judgment on the pleadings. Maybe summary judgment if the evidence is really overwhelming, right? The second point on the screenshots and the de minimis argument, I think this is where we've got some interesting law being developed. Basically saying, look, even though it's just a single frame from the larger work, it's recognizable. They're saying it's not automatically a trivial thing just because it's a single frame from a longer video. They actually went back to the Ringgold versus Black Entertainment Television. That was the Rock TV show where they had the quilt poster in the background, and they held that in that case it was not fair use; it was an infringement because it was fully recognizable, the whole poster. And here they're saying, look, this is even more so because it's the whole frame. It's the signature frame of the footage, and so the original is wholly recognizable in the secondary work. So we're getting into this question of, is this de minimis thing really about whether it's recognizable, or is it relative to the whole, which feels like that amount and substantiality argument in the fair use discussion, right? A little bit. How much did you take?
Yeah.
So here they're saying just because it's a small piece substantiality is a factor as well. We have to consider that. And then on the embedding under the YouTube terms, the court affirmed the dismissal there. So what Town Square had done was just use the YouTube's embedding player, and it was considered licensed, not infringement. So there you go. So remand for further proceedings. Okay.
Yeah. All right. Well, all the Swifties out there, rejoice. So we've got kind of a continuation of what we talked about several episodes with Matthew McConaughey and his trademark filings to hopefully thwart some AI uses of his name, image, and likeness. And Taylor Swift has applied for 3 new trademarks covering her voice and image for the express purpose of deterring AI deepfakes. She has filed applications for her saying, hey, it's Taylor Swift, and hey, it's Taylor, as well as an image from her on stage, which was used on the Eras Tour posters. I saw it on a building wrap, a pretty iconic use of her image that's been used within this last tour. All 3 of the applications are under Class 41. All 3 of the applications were filed as in use, so you can look at them and see what they used for a specimen of use, as well as, especially for the image one, the drawing that was submitted in connection with that application. I'm just really interested to see how these are going to be enforced.
Yeah. Yeah.
How broadly will the enforcement go? If a different image of her is used.
Yeah.
Is it going to tie back to that? I mean, that's really maybe somewhat of a copyright infringement issue as well as related to the image. But we'll see, because I'm having these conversations as well.
Sure.
And trying to figure out, as well as I'm sure you tell your clients too, it's great if we get a trademark registration, but if you're not willing to use it to enforce your rights appropriately, if you're not willing to appropriately use it to enforce your rights, while it might discourage someone from trying to get a trademark, filing a trademark or getting another trademark, you still got to enforce it.
Yeah. Well, it's interesting seeing celebrities and their teams, of course, trying to basically use trademark law as a proxy or a substitute for other forms of identity protection when right of publicity, for example, might not work because it's either not commercial use or it's if it's not commercial use, is it even subject to trademark infringement analysis? But not all states recognize the right of publicity, right? So there's a component. I was just thinking about and this is a new case that we aren't reporting on in this story, in this episode, but I think it's Olivia Rodrigo is suing Samsung. Is that ringing a bell?
Oh, I don't know.
No, it's Dua Lipa. Sorry, Dua Lipa suing Samsung because the box that their televisions come in has a big shot of her on a screen, basically. And
yes, having just purchased a TV in the last year, they do. They will have images on the box
and
from some program.
Yeah, and she does have some trademarks for her name, Dua Lipa, but not for her likeness. And so if McConaughey and Swift and others are able to register trademarks for their likenesses in commercial uses associated with various kinds of products and services, it makes a question: do we have to register in 45 classes to cover everything? But and then you have to have
interesting
actual
again.
Use.
And this can, excuse me, I mean, there could be state law claims for misappropriation, as well as you don't have to have a federal registration to bring a false endorsement claim under the Lanham Act.
That's true. Yeah.
Which is where I would think if I was sending the letter, I would be arguing.
Hang your hat on that. Yeah, absolutely.
Right. And because of the fame of the artist and the breadth of distribution of the brand, you could bring a suit in pretty much any jurisdiction you wanted to. So, forum.
And, it also raises...
You could find a good forum.
Sure.
I was going to say you could find a good forum, or as the court likes to call it, I think you could forum shop because of everybody, which ties into our next case we're going to talk about. Everybody probably is subject to jurisdiction in every state.
Welcome to the new world. Another interesting aspect of this is that they're registering clips of their voices. So these voice rights are becoming a battleground. Now, previously we would have looked at cases like the Bette Midler Ford case, or the Do You Want to Dance, or the Tom Waits Frito-Lay case, right?
Or Here's Johnny.
But with registration of trademarks for sounds, it's not just the MGM Lion and the Harley Davidson rumble of the muffler, right? Just the sound of, hey, it's Taylor, or I don't know. I don't know how you protect against someone using a different quote in Taylor's voice, a deep fake recording of Taylor Swift or whatever.
Yeah, I don't know either, other than we've talked about it, the Texas law that helps with deep fakes. but might be more geared toward visual image deepfakes. And then we've again have these conversations every session in Congress as to what could extend to protect against the deepfakes.
Right. Well, and then there's the Elvis Act.
I'm forgetting if that law passed.
Yeah.
Right. If the Congressional Deepfakes Act passed or not.
The No Fakes Act is still sort of in limbo.
It's still going. Okay.
Yeah. So, there's lots of questions about how and if this can be enforced, but it's certainly a reasonable relatively cost-effective step to take to try to line up some arguments in these cases. And we'll be seeing as they move forward. If someone does infringe on one of these people who has a registration, it'll be fun to watch. So
it will be. And then I just wonder how many of these are ever going to make it to be, where we see a decision, unless, and this is an interesting one, especially with Taylor Swift. I can't imagine it ever playing out in the public eye that's not for her benefit. If someone were to be, I don't think she's going to be going after fans.
Right.
So.
Right. No, I think in her case, it was reaction to, wasn't there a deep fake about her endorsing Donald Trump in the last election or something like that?
Yeah, there was.
So, how do you avoid or prevent that? Maybe this is a play to accomplish that. We'll see. Let's talk about Frida Kahlo's estate. This is an interesting civil procedure lesson, I guess you would call it. Really. The case is called Frida Kahlo Corporation versus Pinedo. And it's an 11th Circuit appeal from the District Court for the Southern District of Florida. The Frida Kahlo Corporation is a Panamanian company that has a principal place of business in Florida. It owns the trademarks and copyrighted works pertaining to Frida Kahlo, the artist. Frida Kahlo Investments is a Panamanian company with a Florida office assisting with trademark management. So that's the plaintiff side. On the defense side, we have Mara Cristina Teresa Romeo Pinedo. That's a mouthful. Her grandniece, the grandniece of Frida Kahlo, who is a resident of Mexico, and Familia Kahlo S.A. de CV, which is a Mexican company in which Pinedo is an owner and former officer. So go ahead.
And I'm just gonna insert kind of chain of title. Frida Kahlo died without children. She left all of her rights to one niece, even though she had other nieces and nephews. And this goes down through this line that goes to this Mara. And all of these descendants did a deal at one point with the plaintiff. So we have a deal that was done. And I guess factually, this in 2004, this Frida Kahlo Corporation was formed with the family members and another individual. Yeah. So
anyway, there have been
I guess, of owners over the years. Yeah. And then once they kind of formalized things, that entity and the family became at odds. And so that's where we're at.
Yeah, it hasn't been without friction. There have been a number of disputes over ownership and litigation in many different countries over who owns what and gets to do things and exploit things. So in this instance, the defendants issued some cease and desist letters to certain of plaintiffs' licensees in different states, eventually reaching one called CIC Media TV. This was in 2021, and other business partners the year following. And they kept sending more cease and desist letters. Those letters claimed rights to Kahlo's name and image and threatened to sue, and claimed that the defendants owned the copyrights, trademarks, and image and likeness of Frida Kahlo. So the plaintiffs filed their suit claiming tortious interference under Florida law, That's the intimidation of the licensees there. There were some Lanham Act violations and action for declaratory relief, of course. There was a copyright claim initially included, but that was dropped. And then the defendants moved to dismiss, saying lack of subject matter jurisdiction, arguing that there was a forum selection clause in one of those contracts that said Mexico City was the place for the suits. And they also argued lack of personal jurisdiction. So the district court dismisses and says that Familia Kalo satisfied the long arm statute in Florida, but Pinedo was protected by the corporate shield doctrine. And they said that due process wasn't satisfied because sending cease and desist letters alone did not amount to sufficient minimum contacts. The old international shoe standard, right? So plaintiff appeals, and here we are in the 11th Circuit. The court looks at the long arm statute to ask, is there jurisdiction over the defendants? And held that both defendants do fall under Florida's long arm statute. It covers non-resident defendants that personally or through an agent commit a tort within Florida. The case involves an interference claim, a tort. The corporate shield doctrine doesn't apply to Pinedo because the letters explicitly stated they were sent by a manager of the corporation in Pinedo's individual capacity, stating that Familia Kalo was representing Pinedo. She stated that she didn't conduct business in Florida and therefore wasn't subject to jurisdiction. And the court said, no, the long arm statute, applies. This tortious act, it covers you. And then on minimum contacts, the court applied both the effects test and the traditional test. So did the claims arise out of or relate to contacts with the forum? The court says yes, definitely. The cease and desist letters were sent to parties in Florida and threatened litigation, which is why plaintiffs sued in the first place, and the damage occurred in Florida. Was there purposeful availment of the forum state? District court noted that they applied only the minimum contacts test and not the effects test, but the appeals court disagreed with that lower court ruling. They said that the effects test requires a showing that defendant committed an intentional tort aimed at the forum and caused injury within the forum. And we've already seen that those cease and desist letters happened in Florida, was an interference with the contracts, and caused damage there. So all those prongs were met. Under the traditional minimum contacts argument, the court required that contacts are related to the cause of action, involve an act by which the defendant availed themselves of doing business within the forum, and should have resulted in the defendant anticipating being hailed into court in the forum. So again, the defendant sent those cease and desist letters, which was the whole basis for the tortious interference claim, threatened litigation, that's the availing component, and should have known that they could be involved in the Florida courts based on that. So sending allegedly tortious cease and desist letters into Florida was purposeful availment. So interestingly, this is a note from John, our managing editor. The court stated that for patent litigation, settlement communications or communications threatening a suit are all that you need to establish personal jurisdiction. And this decision seems to be taking this a step further into this kind of litigation. That's interesting. Then the court looks at... Go ahead.
Well, and I was just going to say, I guess it just doesn't matter if these were foreign entities in the way of being from a foreign country or a foreign entity as defined as being
from a different state.
Entity formed under a different state.
Yeah. I don't know. I wonder if the analysis would be different if they could have gone to court in Nebraska, but they chose Florida, and then it was a sort of a forum shopping thing. Maybe the court would have looked at it a little differently, but here we are. The facts of this case are what we're dealing with. So,
right.
On a fair play and substantial justice analysis, the court took a look at the burden on the defendant and the forum's interest in the dispute and the plaintiff's interests, as well as the judicial system's interests, and found that there was litigation in 2 other countries. So that fact showed this is not a significant burden on the defendants. Florida is interested because Frito Kalo Corporation is located in and a citizen of both Panama and Florida. And the business relationships in Florida were harmed. So the plaintiffs have an interest in receiving relief there, and the legal system an interest in enforcing U.S. trademark laws. So, which wouldn't be applicable in either of the foreign litigations. So civil procedure, 201, I guess. But the key focus that counsel need to think about is that demand letter, all of us, we need to think about merely sending a demand letter or a cease and desist letter, or even just entering into settlement talks could, at least in the 11th Circuit, could mean you're availing yourself, and therefore you are subject to jurisdiction in those states. But this is, a unique set of facts. So it may be that that's what's created sort of an unwieldy outcome in this instance.
Yeah. But it should make us all pause as we're writing those letters and as we're advising the client as we write those letters.
Counseling the client about the potential ramifications of sending a cease and desist letter. Now, that's an interesting conflict with the duty to enforce one's trademarks, isn't it? If we don't enforce them, we have equitable estoppel or laches kinds of defenses, and you could lose the mark. So we have to counsel our clients, you have to do this, but be aware you could get sued in that place.
Right. And I guess I often think, we could get a deck action.
Yeah.
But, again, these would be, this wasn't a declaratory judgment action of validity of a trademark. Right. This was a action brought on you're tortiously interfering or intentionally I guess it wouldn't be intentionally, it'd be tortiously interfering with a business contract. So now you're subject to jurisdiction.
Well, and I think that's probably the bigger mistake, is that the tort, because a lot of this hung on the fact that there was a tort committed. I think merely threatening the other party doesn't amount to a tort until you contact their business relationships and threaten other people. Hey, we own it. You better stop or else. And you're not talking to the party that has granted them the license, but you're talking to the actual licensee or whatever. So again, it may be that complicated facts make for complicated law in this particular instance.
Sure. But again, I think it's a good reminders for us.
Sure, absolutely.
As we work with our clients on protecting the brand, the copyright, whatever the asset might be.
Right. Well, meanwhile, across the pond, why don't you take this one?
Yeah. So I know over the years we've talked about Jimi Hendrix and intellectual property related to both his brand, the trademark, as well as his copyright assets.
Indeed.
Numerous times over the years. And we did talk about this particular case back in February of 2022, episode 142. It's litigation brought by the companies representing the estates of Noel Redding and Mitch Mitchell, the bassist and drummer of the Jimi Hendrix Experience. They recorded and played with Jimi Hendrix. In particular, this litigation is about 40 studio recordings between 1966 and 1968. There was a recording contract signed that my understanding is these two guys plus Jimi Hendrix signed assigning certain assets into these recordings that were made, as well as after Jimi Hendrix passed away, these two gentlemen signed new agreements and releases into the Hendrix estate related to these rights. But this suit has been brought in the 2000s or the 2020s, and the estates for the two gentlemen argued that the musicians were entitled to two different types of assets. One was reclaiming copyright interest and royalties in the recordings, and the other was related to their performance within those recordings. A little bit different from how we look at things in the U.S., partly because we really don't separate out that performance right from the actual recording, what's captured in the copyright. Sony, who's the party to this case, Sony Music, acquired its interest through a succession of rights transferred tied to Hendrix's original recording agreements and later catalog transactions. And they argued that the contracts executed at the time, both again those in the 60s and then those releases, validly transferred the relevant rights, and that they just waited too long to sue. Yeah. And the court did agree, and this is the High Court in the UK. I have not read the whole opinion, but I'm going to. It's on my list. And I encourage folks to, because I love how this judge, and maybe this is how all the UK judges organize things, but man, they just give you the roadmap literally at the beginning and tell you where they're talking about specific claims. It's so very well organized. Yeah. Anyway, the agreements entered into during the 60s effectively assigned those relevant two sets of rights. The estates could not reopen or undo those deals, plus those releases later on. We have in the U.S. the termination provisions that come into play. Those are not part of the UK law or function differently. The UK copyright law term is very different. The UK copyright law also had protection for sound recording copyrights in the 60s, as opposed to us not having those.
Not until 72, yeah.
Not until 72. So it is just really a different set of law from what we're talking about in the US, and that's really important for us to focus on. And again, there was also, they focused not only in the recording agreements on these releases, but also on the discontinuances, which I believe is the fact that the band broke up.
Yeah.
They discontinued functioning as the Jimi Hendrix Experience. So I think it's something we need to look at and kind of compare and contrast to this decision in Vedder v. Resnick, which we just discussed over the last year and even earlier this year, where the Fifth Circuit was saying that these copyright grant termination rights extend well beyond the grant in the U.S., and now we've got this UK law that's clearly saying we're just following these contracts. And so even though there may have been deals done in the US, it doesn't apply here.
Makes me wonder, if
is this a bit...
These plaintiffs couldn't have fared better if they'd filed in the US and terminated transfers under US law. But a lot depends, I guess, on where the recordings were made.
Well, they couldn't.
Right.
Because of the 60s.
Oh, right.
I mean, obviously, they would have their wind. I haven't calculated the window, but I'm betting they were outside the window to file.
Oh, good point.
And in light of these releases they signed, I think it would have been similar to Steinbeck. Isn't the Steinbeck where the spouse re-signed a deal and then the children couldn't come back and reclaim that termination?
That rings a bell.
I think it's that one. Yeah. Anyway, are there broader industry implications? I work on both sides of these deals. Does it really strengthen confidence in long-held catalog ownership? I don't know.
If you're a British record label.
If you're a British record label, it does. Do we think we would see similar legacy claims by estates or session players being discouraged from taking those actions? Perhaps. Again, I think part of this is we don't have this separate performance right. If we have any UK lawyers listening, we'd love to kind of hear your response on how that interacts with their claims. I just don't know. But what we do know is those early contracts are definitely going to shape the future for ownership for generations. Unless we're triggering in the US these copyright grant terminations, and now we have Vedder, which has given us all kinds of uncertainty as to what it actually means when you effect a termination under the U.S. copyright law.
Does this case change anything with respect to their right to receive royalties? I mean, were they already receiving royalties and they were trying now to reclaim the copyright or interest in the copyrights?
I don't know what the language of that 70s release included.
Okay.
There was also conversation, and this is where I got a little thrown off because I don't think we would be having this particular conversation in the U.S. as to who paid for the recording.
Yeah.
And that the who paid for the recordings could somehow have ownership. Again, we have at that point in time, if they'd been recorded in the U.S., there was no definition of work for hire.
Right.
So,
and the thing is,
it could have been, and they don't have that in the U.S. They don't have in the UK, I don't believe there's an analogous work for hire type argument.
Yeah. Well, and this was more than session players. They were members of the band, which still I think was Hendrix was the owner, and they were sort of, if not employees, they were contractors. You know, I don't know the details of what the band agreements looked like back then, but it's not as if they were merely session players hired for that session. So that I don't know.
Well, I think they were signed to the recording agreement.
Yeah, I think so. That's why the release is later. Yeah.
Well, that's why the release is. Yeah. So it does make you. I don't know that standing is appropriateness is out of the question as to it. It's just. I think we would look at it from a laches standpoint in the U.S., maybe a statute of limitations standpoint in the U.S.
Yeah.
And we don't have a window related to the termination. So, I think it's something we need to look at if you're working with estates who recorded in the U.S. and outside the U.S., maybe trying to figure out where you want to aim that litigation, and maybe there's only one appropriate place, and it sounds like this was in the UK.
Sure. Well, we have an update on the fair use decision in favor of Netflix over that Tiger King material. It was April 30th. The 10th Circuit Court of Appeals issued a decision on fair use. The case is White Monkey Productions, LLC, and Timothy Seppi versus Netflix and Royal Good Productions. Regarding that Tiger King documentary, in episode 167 of our show, we covered the 10th Circuit's original ruling on the dispute, which centered on a 1 minute, 6-second video clip that Seppi had recorded of Joe Exotic, the subject of the documentary. He was delivering a eulogy at a funeral that was featured in the documentary, and the district court found that the use of the video clip was fair use. On appeal at the time, the 10th Circuit found that it did not qualify as fair use, and they relied on the Warhol decision from the Supreme Court and concluded that the use of the video clip wasn't sufficiently transformative under the first factor of the fair use test, as they did not make any commentary on the original video. The 10th Circuit agreed with the lower court on the second and third factors, the nature of the work and the amount and substantiality, and then they found that the lower court's analysis of the fourth factor, effect of the use on the potential market, was insufficient. So it gets remanded to the district court for further examination of the fair use factors, but the defendants filed for a rehearing. And they had several law professors and industry organizations, the International Documentary Association, Film Independent, University Film and Video Association, all of them filed or joined in amicus briefs in support of Netflix. So a second round of oral arguments is heard and focused on how core fair use principles apply when documentary filmmakers use footage for purposes cited in the Section 107 preamble of the Copyright Act. The preamble lists the types of copying that courts and Congress have most often characterized as fair use: criticism, commentary, news reporting, teaching, scholarship, research, and so on. So the new decision says that the use of the funeral clip was indeed fair use. They looked at two cases in the analysis. One was Bouchat versus Baltimore Ravens Limited Partnership in the Fourth Circuit, and Elvis Presley Enterprises versus Passport Video from the Second Circuit. both of which illustrate how fair use often protects use of copyrighted works in documentaries because they are frequently animated by preamble purposes and transformative in nature, copying only limited snippets in pursuit of significant and distinct purposes. So here the video was used to show Mr. Exotic's sort of megalomania and showmanship, even in the face of a tragedy. The court found that was an objectively different purpose than the original video's purpose. And to a significant degree, it was transformative. The court called the use classic documentary style borrowing and noted that defendants used the video clip as part and parcel of a work reflecting the Section 107 preamble purposes we talked about. So it doesn't risk superseding or supplanting the plaintiff's original use of the video as it did in Warhol. Here, the use was also insubstantial. 1 minute and 6 seconds taken from a 24-minute video. Sort of contrary to what we were talking about earlier with the de minimis thing. So the court held that that incidental, insubstantial use is unlikely to substitute or supersede the original copyrighted work in the market because the use was for an objectively different purpose to a significant degree, and that use was insubstantial. So the court concluded the defendant's use was significantly transformative and fits well within the mold of those documentary cases where courts have found fair use. Plaintiffs emphasized the lack of defendants' comment on the original work as an argument against fair use. But the court said they did not need to comment on or target the video for there to be a finding of fair use. This kind of independent justification is really only relevant where the original work and the copying use share the same or similar purposes, like parody, which isn't the case here. So, commercial nature, the court found any commerciality of defendant's use does not tip the balance away from finding of fair use, and they upheld their original ruling on the second and third factors to find fair use. So, and they also said that factor 4 tipped in favor of fair use because the transformative use of the video undermines the likelihood of market harm. Undermines the likelihood of market harm for Seppi's funeral video. So, affirmed the district court's summary judgment and find all 4 factors favoring fair use. So, kind of a big switcheroo on their ruling.
Yeah. I like that the court addressed this question about commenting on the original work and where that's an appropriate consideration and where it's not.
Yeah.
As we've talked about a lot of times, that, Weird Al Yankovic, to my knowledge, always gets a license.
Yeah. I think that applies in a parody analysis, but not every fair use analysis depends on it.
That's right, because we're looking at those songs as a potential, are they a parody or not? And maybe they're not, but it is the same type of work that's being released. Yeah. And so probably not fair use in the respect of those songs, but also needs not fair use and needs a license. So they're not commenting on the original underlying work, even though we might say it's a parody of the work.
Yeah. Are you a Star Wars fan?
I just...
Oh, go ahead. Sorry. Finish your thought.
I know. I was going to say no. I was just going to say, as far as I know, Tiger King is still in jail down the street from me.
Oh.
So...
Okay.
But now you've got me maybe wanting to return to 2020 and watch them again. I don't even know if it's still on Netflix. So.
Okay. I don't either.
Nor do I know that I should go back.
I never watched it in the first place.
That was only 2020 appropriate viewing.
Exactly.
I think.
You're locked up in your house. You got nothing better to do. Right?
You got nothing better to do. You're going to watch Tiger King. Yeah. I'm not saying I am not a Star Wars fan, as in I'm anti-Star Wars or
Understood.
like I'm a Trekkie. I'm just
it's not
a Star Wars fan.
Yeah.
It's not big in our life, even with a very nerdy kid. Okay. Not a big thing. Yeah. So,
well, here in my house, I'm a big Star Wars fan. I mean, I have vivid memories of cutting school when I was in the what grade would that have been? 6th or 7th grade, to go see the premiere of Star Wars, or not the premiere, but early screenings in 1977. So,
yeah.
Definitely a big deal in my life. I'm wearing Darth Vader socks at the moment. We have bobbleheads from all the various, I should say, Funko Pop characters from all of the various Star Wars movies, and I'm a big fan. So, the reason I bring that up is that we have a case involving some photos of the Star Wars cast members taken by Annie Leibovitz back in the day. And the case is called Great Bowery Inc. versus Consequence Sound. And plaintiff here is Great Bowery goes by the AKA Trunk Archive. They sued defendant Consequence Sound for infringing the copyrights in photos that it held an exclusive license to. The photos were taken by photographer Leibovitz, who entered into an artist agreement with Trunk Archive, granting them the exclusive worldwide right to license, market, and promote certain images that she had created, including these Star Wars images, though she reserved the right to collaborate with or deliver any of those images to Robert Pledge and or Contact Press Images for certain special projects and other endeavors. Well, in 2022, Great Bowery files suit in its own name against this defendant, Consequence Sound, after discovering some of the Star Wars photos appeared in articles on www.consequence.net, which is a website operated by the defendants. Great Bowery moved to amend its complaint to add Leibovitz as a co-plaintiff, but that was denied as untimely. During discovery, Great Bowery provided an authorization letter permitting it to act on behalf of Leibovitz in all matters relating to copyright infringement of her work. So no depositions were taken, and the parties cross-moved for summary judgment, and defendants argued that Great Bowery lacked statutory standing to bring an action for infringement because it was not a legal or beneficial owner of an exclusive right under copyright. Well, the district court agreed with that. They found that neither the authorization letter nor the artist agreement granted Great Bowery an exclusive right under a copyright, reasoning that, one, Leibovitz retained some rights for herself, and that meant she didn't grant them an exclusive license, and two, because Great Bowery wasn't an owner of an exclusive right, it then lacked standing under Section 501B to sue for infringement, and granted the motion for summary judgment by the plaintiff. They granted Consequence's motion for summary judgment and denied Great Bowery's motion. So Great Bowery appeals to the 11th Circuit on the issues of the denial of the motion to amend and the granting of summary judgment. They argued that the court is required to grant the motion no matter how untimely, because 17 U.S.C. Section 501B provides that, quote, the court shall permit the intervention of any person having or claiming an interest in the copyright. The Ninth Circuit didn't like that argument. 2 grounds. They said Leibovitz never actually sought to intervene, so that was irrelevant, the section in question. And second, even if that statute did grant an unconditional right to intervene, any such motion would still need to be filed in a timely manner under Civil Procedure Code Section 24A of the federal rules. On standing, the 11th Circuit vacated the district court's order granting summary judgment in favor of the defendants. The district court ruled that because Ms. Leibovitz clearly retained the right to grant licenses to other parties at her own discretion and retained some rights for herself, she hadn't granted an exclusive license. The court said that the district court...
I'm just going to interject. Is that not also what you would...
Right.
Default to your understanding? Okay. That is the understanding I default to as well.
Well,
go ahead.
It's interesting because if it's the exclusive right in certain territories, copyright is divisible, right? So if they could have an exclusive right with exceptions, I guess, is that non-exclusive then? Well, that
if we keep some kind of carve out, I think we can all understand that just because the document says it's an exclusive license, that
is it really exclusive?
Matter. Is it really exclusive? Yeah.
But
anyway, I'm sorry.
No, but if I grant you the exclusive right to adapt my novel into the French language and someone infringes it in a French film, do you not have an exclusive right? You're the only one who's supposed to be able to do it in French, right? So I think this is an interesting, I don't know if it's an appealable issue or not, if it's likely to be appealed, but we'll see. Anyway, so she hadn't granted them an exclusive license, says the court. The 11th Circuit went on to say that the district court's understanding of copyright law was, quote, not quite right, and found that Leibowitz's retention of certain rights doesn't automatically prevent Great Bowery from claiming status as an exclusive licensee, since copyright rights can be divisible and subdivisible. The court, though, did decline to decide whether such an exclusive license existed and remanded it back to the district court with an emphasis on evaluating whether or not the same sticks in the bundle overlapped. So the bundle of rights.
So I'm wondering how on the sending or receiving of copyright infringement related cease and desist letters. Sometimes those that are egregious and overreaching and they've done no true evaluation of the claim. If we're responding to those, do we begin to further argue this as to your client has no standing?
Well,
or does it work? Is it now going to work against us if we're arguing your client has no standing? If our client is the one that's receiving that letter, asserting copyright infringement.
Right. Well, here's an interesting wrinkle to that is that, in a lot of these photograph cases where you've got some of these rights management organizations, I'm thinking of, I don't want to name names, but I'm dealing with a few of these.
Yes.
Where they come in and say, you're infringing this work. We're demanding this much money. If you pay by this, we'll settle. And then you end up,
that's what I was alluding to as well.
I've gone back to these folks and said, hey, show me that you've got standing. Show me that you've got a registration. Show me the licensing history so we can evaluate the damages amount. And then we'll talk. And, they always come back saying, we don't have to show you anything. You can settle or not. So,
yes, we're going to charge you more if we have to do our due diligence. Right. And that really only matters if we sue you.
Right. Exactly. But I mean, here, this question of if you don't have an exclusive license or an assignment of the whole copyright, you don't have standing to sue.
That's right.
So get out of my face.
Or do you?
And a lot of these organizations aren't law firms, right? They're just an agent that's been engaged to try to collect on these things. So I think this changes the analysis. It changes the bluff calculation a little bit.
It might, and maybe only if you're in the 11th Circuit, which is Florida. We've already talked about it was Florida. I don't know who else is in the 11th Circuit. So, interesting. We again put that one, if everybody put that one in the back of your brain, it may come back, and we need to need to understand it. So.
And this is 11th Circuit. I think at one point it mentioned the 9th Circuit, but this is an 11th Circuit decision. So we may or may not see this applying everywhere. I think the analysis is right that if you don't have exclusive rights, you don't have a right to sue. Although I'm doing a deal right now where it's a limited exclusive license. In other words, the owner of the IP actually gets to continue using it for their own purposes, but they will not license to anybody but this other licensee. And it purports to grant the licensee the right to sue. I don't know if the contract granting that right amounts to anything or not, given this kind of an analysis. So,
well, and that was the case. I never thought we'd forget the name of it because we talked about it all the time. Out of Nevada, New Mexico, early on, a decade ago.
Those, I can't remember the name of the outfit either, but we did talk about it a lot. And
then that's when, right, and that decision came out of that court case was you've got to be the exclusive owner.
Yeah.
or you've got to have all the exclusive rights or be the copyright owner to have standing to sue. Yeah. What is the name of that case?
We're both blanking on it, but it's, hey, it's 15 years ago. So.
That's right. And that was what we've been operating under. Yeah. And now we have a case that may be saying something a little bit differently. So we're going to have to put those together.
Well, maybe this is another item that needs to be on the list of things that we would love to have Congress address at some point. And that shifts us over to the testimony from the Copyright Office Director, Shara Perlmutter. Earlier this month, she told a Senate Judiciary Committee subcommittee, that Congress needs to revisit major portions of U.S. copyright law, particularly after the Supreme Court's decision in that Cox Communications case. In that case, the court held that the ISP was not secondarily liable for subscriber infringement, despite allegations that it had failed to terminate repeat infringers. So she warned that ruling may have created a big hole in the law because the DMCA safe harbors were designed to shield platforms from liability. But the court's reasoning really suggested the underlying secondary liability standards there may be unclear. She suggested Congress really may need to explicitly codify those standards and clarify that. Well, the hearing then broadened and became a larger scale discussion about whether copyright law is ready for AI and streaming and digital distribution. And Perlmutter reaffirmed that copyright protection still requires human authorship. She noted that AI-assisted works may qualify if there's sufficient human creativity involved. All the stuff we've been talking about the last couple of years. She's emphasized also that whether AI training on copyrighted works constitutes fair use is unsettled and highly fact-specific. And then it got into addressing things like deepfakes, AI-generated voice and likeness replicas, and renewed interest in site blocking legislation, which is the kind of measure that a lot of European law has adopted. So interesting. So, one commentator, Jonathan Bailey from, Plagiarism?
Plagiarism Today.
Plagiarism Today. He argues that many modern copyright disputes really hinge on these judge-made doctrines rather than clear statutory guidance. That's nothing new in the law, but he said, this has caused some confusion, especially following the Warhol case from the Supreme Court, which has led to, some other inconsistent rulings here and there, trying to apply a 50-year-old law to a modern environment. He suggests that AI may be the greatest pressure point on copyright law these days, and it brings up all kinds of unresolved questions, training data, authorship, liability for AI-generated outputs. And he stops short of calling for a complete rewrite, but he argues in his article that we may need a sort of a new DMCA, a big copyright, plug-in that fixes some of these things or addresses some of these things.
And you and I have been talking about this.
We've been saying it for a decade. And we've also been saying for a decade, good luck getting Congress to do anything meaningful these days. And I think that's sort of where we are. There's a need for these changes, but not the stomach for it right now, I think. Or I wouldn't say not the stomach, not the, nobody has the political capital to make a meaningful change to the law right now in this. Yeah. So that's interesting. We will see.
I don't know. We got the music licensing.
Yeah.
The modification through. Mm-hmm. But maybe there was a lot of tech companies on the other side of that conversation. I'm just thinking there's a lot of tech on the other side of this conversation too, as far as revisions to the DMCA.
And far better funded than the individual artists and the organizations that tend to represent artists. So
right.
Maybe it's better if they don't go in and tinker with it too much right now. So, yeah. Well, what about Moana? This was an interesting, I shouldn't say Moana. It's the Moana lawsuit that has been dismissed with a significant sanctions award. or
Yeah,
attorney's
we
fees.
don't like to talk about sanctions, but we will. The plaintiffs are Buck Woodall, an animator, and a self-professed forger of documents. Interesting. The defendant is the Walt Disney Company. This was in the Central District of California. In 2020, the plaintiff, the animator, sued Walt Disney Company and various other entities and individuals, accusing them broadly of copyright infringement for his film, quote, Bucky, about a teenage surfer traveling back in time to ancient Polynesia. Woodall said he shared his materials with Jenny Marchek, his sister-in-law's stepsister, and claimed that she signed a confidentiality agreement and then passed along the materials to Disney. And Disney, of course, created Moana and the Moana 2. There was a 10-day trial with a jury verdict in favor of the defendants due to the plaintiffs, failing to show access. At first I read that as failing to show up. Well, that will usually cause the problem. But it might not take 10 days. But anyway, failing to show that Disney had access to his works. And the defendants moved for sanctions. What are sanctions asked for? So the confidentiality agreement was falsified. Plaintiff had a signed confidentiality agreement with an unidentified and undated signature. He then, in his deposition, admitted to having written the name and dated the document in 2020. And I'm not sure if John put this in. We have an editor's note.
Yeah.
The favorite line from the depo is, "I'm not an attorney. That's my attorney's job to make those calls. I have no idea." And this was his response when asked if the fact that he backdated it and wrote on the agreement central to the complaint was that material.
Don't you think that matters?
He did make it.
I'm not an attorney. I don't know.
Yeah, I don't know.
Oh.
Making it worse, plaintiff's counsel wrote the following, quote, "On a final note, you have suggested that either some or all of your clients will ultimately claim the Marchek confidentiality agreement is a forgery, and we appreciate you advising us of same. However, your clients may wish to note that easily disproven facts or perjurious comments about the veracity of certain documents is likely something they should think carefully about before introducing them into the fray."
Listen, you don't really want to bring that in because, you don't want to bring it in with no explanation.
Yeah, really.
Then at trial.
Yeah, and so, go ahead.
He acknowledged
signed it.
that it wasn't her signature. It was someone else's. And he testified that
to
his
make it look
were
like
concerned.
her signature. Yeah. So I don't know how this happened, but notably some of the counsel were excused from sanctions because either there was nothing that tied them to reviewing and approving of the filings, or it was documented that the counsel in question did not participate in the initial complaints and had no falsity of the documents. It just didn't have knowledge. But there was also trade secret claims in this. That's interesting.
Well, if there was confidentiality, then some of that stuff might have been
trade secret. Disclosure. It could have been a trade secret that was disclosed.
Fudging dates, too?
Yeah. Plaintiff's complaint claimed he first saw Moana on DVD in June of 2017. At trial, he stated he saw it in the theater in 2016 and suspected it had been copied. Litigation was filed in 2020, running up, that 3-year statute of limitations, trying to, claim a date that would make it fit within the time frame. The court assumed that even if the plaintiff initially lied, he then said it was 2016 in a deposition. Obviously, he can't get his facts straight. The court ultimately awarded the defendants over $475,000 in sanctions, and in addition to the over $1.5 million that had been awarded for other sanctions.
That was the attorney's fees, I think, was the $1.5 million.
That was the attorney's fee. So just crazy. If you know your client's lying, just stop.
And if you wonder if your client's lying, investigate, right? I mean, is this document for real? That's starting point. And then, wait a minute, when did you see the movie? And when did we file the suit? Let's not go fudging the dates.
And maybe they figured all that out and tried to get a settlement, and Disney said, no way.
Oh, they knew. Yeah. Well, yeah. I mean, if they had just dismissed,
withdrawn.
Right.
Yeah.
Well, interesting. Well, our next story is one that we ordinarily don't talk about cases from other countries very much, but this is sort of an interesting wrinkle. It's been 25 years in the making. This lawsuit has been going on for 2.5 decades. It's a case in Germany. It's one of the longest running copyright disputes in music history, and it's sort of wrapping up now. It involves a German electronic band, Kraftwerk, with a K, and producer Moses Pelham over a 2-second sample taken from Kraftwerk's 1977 song Metal auf Metal. Pelham used the loop in Sabrina Setlur's 1997 song Nur mir, and Kraftwerk sued in Germany in 1999, arguing copyright infringement. At first, the German courts largely sided with Kraftwerk and held that the unauthorized sampling infringed their sound recording rights. But the case bounced through the appeals for years, eventually reached the European Court of Justice, and in 2016, that's when it landed there. They initially ruled mostly for Kraftwerk, but then they added in an important limitation. They said, if a sample is altered so that it becomes unrecognizable, there's recognizability again, unrecognizable to listeners, it may not infringe. So the case goes back to the German courts, and they found that the sample was still recognizable and therefore infringing. But during all this litigation, in 2021, European copyright law changed and the EU formally recognized protections for parody and pastiche, creating a possible new defense for sampling cases like this one. So the dispute goes back to the ECG, the ACJ, the Court of Justice, a second time, and the court now rules in Pelham's favor, arguing that it was protectable pastiche under EU law. So now the case still returns technically to the lower courts, but the major legal issues seem to be settled. And the result is essentially a split. They won regarding the pre-2021 use, but Pelham wins, the defendants win, under the new pastiche rules for anything post-2021. So why did this case go on so long? Well, first, the European system has this extra appellate layer because cases can move between the national courts and the European Court of Justice. Also, Germany didn't have a broad fair use doctrine like the US does, so it relied on narrow statutory exceptions that didn't really address music sampling. So all that legal uncertainty leads to additional years of litigation, and finally then the law changes in the middle of things, and the courts had to revisit some of the earlier rulings. So practical result kind of feels like a draw after 2.5 decades of litigation, but the case is hugely important because it gives artists, producers, and rights holders better guidance, really, about music sampling and copyright law in the EU. I had to look up what the word pastiche means, and I can't remember exactly the definition. But basically, it's when you copy a bit of something or the style of something, and it's not parody, it's not meant as satire, it's not commentary, it's not quite homage either, because you're not necessarily celebrating it, you're just imitating a style or imitating a little bit of something. And so that's an interesting way of approaching it, and I think it's sort of it's a different overlay, but it's like fair use in some ways. It's like, well, is it appropriate to do this because it's not too much, you're not taking all of it, and it does sort of, it's changed, it's transformed. The nature of the use is a little different. And presumably there's a market value analysis also. So it feels like it's their version of fair use in the EU now.
It may be. Who paid for this litigation?
I think it's probably, you've got record labels on both sides, right? I mean, Kraftwerk, the band, but I don't know.
I guess.
And I dare say that it's probably a lot less expensive to litigate in the EU than it is here, just the way structures are set up. And it may also be that this lengthy litigation could be wait 9 months, file a brief, and then wait another 9 months, those kinds of things. So it may not be as intensive as litigation in the EU. I don't know. Also, I think there's cost shifting. And I don't know if
in the European Court of Justice, if that's purely administrative, as in you're not showing up in person.
I don't know either.
I don't know.
I do remember from when I was in law school, we were told that in Germany, in particular, when a party files a case, the court then takes it on and does the investigation and the discovery. And it's not the parties doing all the back and forth. It's the court itself kind of telling the parties, we need this so we can help find this decision. I mean, I don't exactly know it, but I remember that the court is much more actively involved in the process of getting to the truth and isn't just depending on the parties to do their work. So
very interesting.
Yeah. 25 years of litigation. And maybe I wonder we don't have the numbers. Maybe I should
tell my German language speaking family member. Perhaps that's a job for him.
Yeah. Anyway, so that's just an interesting outside the box kind of cap on our episode for this month.
Yeah. And I just want to say pastiche. I think that could be a great trademark for something. It is a nice word.
Yeah.
Kind of like pashmina, pastiche.
Yeah. Pasteles, candy. As always,
Pinocchio.
On that note, we're going to wrap it up because this is the end of our content. So we'll say thank you to our loyal listeners for being with us again for this episode. We appreciate you for spending your time with us and hope that you'll tell friends and share the episode and more about the podcast with anybody who might be interested. And leave us feedback. As I mentioned earlier, you can leave the voice message using that little widget on the website at entertainmentlawupdate.com or email us at entertainmentlawupdate@gmail.com. Tamara, how can folks find you?
You know what? You can find me at harperbates.com, createprotect.com, and also most social media at Tamara Bennett.
That's great. And I'm Gordon Firemark from Los Angeles. My website, firemark.com. My email address is gfiremark@firemark.com. And on most social media websites, I'm gfiremark. And let's give a big shout out to our team of volunteer contributors, Managing Editor John Janasek, Charles Thorne, Alexis Allen, and our newest addition to the team, we want to welcome Lauren Malone. Thank you for all of the work you guys have done on this episode. And we're looking forward to much more of the same. If you are interested in joining the fun, our family of contributors, we're always looking for more help with this. So reach out to us at entertainmentlawupdate@gmail.com. And with that, we will wrap up our episode. And say, that's showbiz.